Hi, Christine Kepp here, new agent mentor for Realty One Group Southwest, and today we're going to be going over the disclosure regarding real estate agency relationship. We're going to go over the form in detail and discuss how to explain it to your prospective sellers. Since there's often a misperception throughout the general public as to what our duties and responsibilities are as real estate agents, the public's confusion led California legislators to mandate a disclosure for the real estate industry to use that clarifies what duties real estate agents owe and to which parties they owe them. This agency disclosure form, CAR Form AD, also sets the standard for conduct for real estate licensees. If you fail to perform your duties as outlined in this disclosure, you could lose your license and be held accountable in a legal claim, so it is important to know and follow these duties in accordance with real estate law and properly represent your client. The purpose of this video is to train you to use the agency disclosure form, one of the fundamental disclosure requirements for California real estate licensees. As agents, we represent sellers, we represent buyers, and there are certain situations where we represent both buyers and sellers, known as dual agency. No matter who we represent, the agency disclosure form helps the public understand what to expect from an agent in various roles. It spells out duties that we owe to principals and to others in a transaction. As with all forms you ask your clients to sign, you must give them a copy and have them sign that they have received it. Keep a signed original or copy of the agency disclosure form for your files as well. The form is required whenever the transaction will be a sale, exchange, or lease of more than 1 year on 1 to 4 residential units or a mobile home. So now let's look at the form in more detail. The agency disclosure is only one double-sided page. The front of the form must be completed and signed by you and your clients. The reverse side contains portions of the actual California Civil Code, which mandates the use of the form. This legalese is printed in dark gray ink on the backside of the form and must be furnished to your clients, but it does not need to be completed. So on the top of page 1, you only check the box if the transaction is in connection with a lease. So if your client is purchasing a property, you will not check the box. The agency disclosure form begins by stating, when you enter into a discussion with a real estate agent regarding a real estate transaction, you should, from the outset, understand what type of agency relationship or representation you wish to have with the agent in the transaction. When the form states from the outset, it means the beginning, the start, or the inception, when you first determine that you may be able to help a buyer or seller with their real estate needs. That's a good time to begin explaining what you can and cannot do for them. Take out the form, go over it, and talk over the duties you owe them as their agent. You may choose to bring the agency disclosure form out much later, when the buyers are ready to make an offer or the sellers are ready to sign a listing agreement, and that's fine. As long as you have them sign the form prior to their signing anything else, you have followed the law. However, why wait? Potential clients may appreciate that you are ready to discuss what you legally can and cannot do for them. They may like knowing this in advance. And the agency disclosure form doesn't commit you to work as the principal's agent, nor does it commit the principal to work with you. Rather, it simply explains how you might work for them. You and your client choose what type of representation you want and confirm it after having been given a chance to consider the options. Those options are spelled out on the form. Your duties depend on who you ultimately represent, whether the buyer, the seller, or both. Now, speaking of representation, the agency disclosure form sets the following 3 types of agency relationships. The seller's agent, if the firm has the listing. Buyer's agent, if the buyer is making an offer on another firm's listing. Or dual agent, if the buyer is represented by the same firm that has the listing for the seller. No matter who you represent, you must do certain things in order to fulfill your agency responsibilities as outlined in the separate sections of the agency disclosure form. These obligations are affirmative, meaning that they require an application of effort on your part. You must do them even if the principals don't ask you to do them. When you represent either sellers or buyers, you owe them a fiduciary duty of utmost care, integrity, honesty, and loyalty in all your dealings with them. As someone's fiduciary, you have been entrusted at the highest level of legal responsibility for his or her benefit. In addition to your fiduciary obligation to your client, you have other obligations which you will provide to both parties in the transaction. These include 3 specific categories: Number 1, diligent exercise of reasonable skill and care. Number 2, honest and fair dealings and good faith. Number 3, you have a duty to disclose all facts that are known to you which materially affect the value or desirability of the property that are not known to or within the diligent attention and observation of the parties. This is the part that may cause the most legal problem for agents. What constitutes a fact as opposed to hearsay or likelihood? What defines material as opposed to inconsequential? What is observable? And can't the principal notice it for themselves? These are great questions, and the best answer is always, if you are in doubt, disclose, 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 unless otherwise prohibited by law. The agency disclosure form spells out one limitation to your duty regarding disclosure. Although you must disclose any material facts which affect the value or desirability of the property, you are not required to reveal to either party any confidential information that does not involve the agent's affirmative duties described above. Moving on to the next section, make sure your client understands the section entitled Agent Representing Both Seller and Buyer, as you may find your firm handling both ends of the transaction. This is called dual agency, and it is legal if both parties give their informed consent. That means they realize that Realty One Group is handling both sides of the transaction, and they agree to it before you begin to represent both principals. Undisclosed dual agency is a serious violation of both agency law and BRE regulations. Penalties can include lawsuit, loss of your license, and full refund of a real estate commission even if the parties don't go ahead with the transaction. If you're heading for dual agency, get both of your principals informed consent in writing to protect yourself and them. What if the seller or buyer does not want your firm to represent the other side in the transaction? Now would be a good time to find out. Any desire by a principal to avoid dual agency will restrict your marketing and sales efforts because showing company listings to a buyer may result in dual agency. The agency disclosure form allows you to discuss these potential situations in advance. Together, you and your principal can decide the best course of action so it never becomes a problem. Just keep in mind that because dual agency refers to the company as well as the individual licensee, you will still be in a dual agency situation if you had a listing and another agent in our office brought in an offer. That's why it's such a good idea to at least discuss the possibility that there could be dual agency at the time you go over the agency disclosure form with your clients. If Realty One Group is the listing and selling firm, you must pay attention to this restriction when negotiating prices. This is dual agency. Don't indicate to a seller that the buyer might be willing to up the offer if countered. Don't tell a buyer that the seller could lower the price. It may be tempting when you or a fellow agent brings in an offer to do whatever you can to make the deal happen. Because you are both dual agents, you're not allowed to disclose these matters without the permission of the respective party. There's a paragraph in the agency disclosure form which cautions the principals that they cannot rely completely upon the agents to protect their own interests. Next, the form spells out that agents are qualified to advise about real estate but not tax or legal matters, and advises them to consult competent professionals for such information. At the bottom of page 1, above the signature block, the form explains to a principal that the law requires each agent with whom they have more than a casual relationship with to present them with this disclosure form. This means that if the buyer is working with another agent, that other agent should also have given the buyer an agency disclosure form. Now, their reaction to you asking them to sign this form may help you to discover if the buyer is working with other agents. If the buyer hesitates, find out why by asking questions. Are there other agents helping these buyers? Are these buyers loyal to you? If buyers are asking for your help, time, your effort, and expertise, ask for their loyalty in return. Now, it is also possible that the buyer is working with other agents who have not presented the buyer with an agency disclosure form yet. This is an opportunity for you to demonstrate how thorough and professional you are. Show them the form, go over it, and answer their questions. Elaborate on what duties you owe them. Explain that you want them to be fully informed and to have every disclosure form to which they're entitled. Ask if the other agents explained the duties owed to the buyers and gave them this form. If not, it makes you look like you're the right agent for them. Buyers usually ask if the agency disclosure form is a contract that commits them to work with you. Although it isn't a binding contract, it will hopefully indicate that they are willing to work with you. Point out that California law requires that agents give the agency disclosure form to potential clients, so clients know what real estate agents must do for them. How do you know this? It says so at the very top, as required by civil code. When obtaining signatures on the agency form, we may handle this in one of two ways. The first option is to generate 3 agency forms in the transaction. One signed by listing agent and seller, the second signed by buyer's agent and buyer, and the third by buyer's agent and seller. An agency form signed by the buyer's agent and seller does not create an agency relationship between the buyer's agent and seller, but is rather for informational purposes. The second option is that agents will still prepare the first and second agency forms stated in option 1. However, instead of having a third form signed between buyer's agent and seller, the buyer's agent may now deliver the seller the same form signed by the buyer's agent and buyer. The seller may sign acknowledgement of receipt of that form on the signature line in the explanation box. No third agency form is needed. So in conclusion of this review, I want to point out that the agency disclosure form is simply that, a disclosure, not a contract. Signing it does not create an agency relationship, nor obligate your clients to use you or your firm. Your client or prospective client signs and dates at the bottom merely to indicate that they have received the form. You sign and date it to indicate that you gave it to them. From a practical perspective, having your prospective clients sign the agency form indicates a possible willingness to have your help. If they don't want to sign this disclosure, perhaps they don't want you to work for them, and you should move on to those that do. You are now familiar with the contents of the agency disclosure form and know when to use it and how to use it. This understanding should enable you to handle the agency disclosure process in a professional manner and even to use the form as an effective marketing tool in your real estate practice. I hope this video has helped you. If you have any questions, comments, or concerns, please feel free to email me or give me a call. And thanks so much for listening.